What factors influence a jury's decision-making process? And how can we build less biased juries? One of the factors that impacts the jury is exposure to pre-trial publicity. The more jurors know about a case, the more likely they are to presume the defendant guilty, even when they claim to be impartial. Pre-trial publicity may divulge information that will be excluded from evidence and distort the way facts are interpreted. One study found that even though participants were instructed to base their decisions solely on the evidence, pre-trial publicity influenced the verdict. Among those exposed to neutral material, 33% voted guilty after deliberations. But among those exposed to prejudicial material, significantly more, 48%, voted guilty after deliberations. This and other studies provide evidence of what is called the CSI effect. This refers to the phenomenon that television programs like CSI and Law and Order lead jurors to have unrealistically high expectations that cause them to vote cautiously for acquittal. Another factor is prejudicial and inadmissible evidence. Despite judges' instructions to sometimes ignore information, it's incredibly difficult to do. The instruction to ignore actually draws attention to the very information jurors are supposed to ignore, and it tends to arouse psychological reactance. If you tell me to stop thinking about purple elephants, for example, I'll probably think about purple elephants. Highly relevant information activates a desire to make the right decision. And so it's even more challenging to ignore relevant information that's also considered prejudicial or inadmissible. However, jurors have a less difficult time ignoring evidence that was obtained through a serious violation of the defendant's rights, such as an illegal search. As a general rule, research suggests jurors are sound decision-makers, but there are some issues. For instance, the extent to which jurors' race impacts their decision-making is complex. The effect depends on the strength of the evidence. When the evidence is weak, jurors may be more lenient towards same-race defendants. When the evidence is strong, jurors may be harsher towards same-race defendants, as if distancing themselves from the wrongdoings of a fellow en route member. The effect also depends on whether race was an issue in the case. In one study, when race was not an issue, white jurors treated white defendants more favorably than black defendants. When race was made a prominent issue in the case, white jurors bent over backwards not to appear prejudiced and did not discriminate. In cases involving the death penalty, and in which the jury makes decisions about the verdict and the sentence, death qualification is typically used. This is because sentencing decisions are influenced by jurors' attitudes toward the death penalty. Death qualification is a procedure used in these cases that permits judges to exclude prospective jurors who say they would not vote for the death penalty. In these cases, then, all jury members need to be open to voting for the death penalty. Its proponents tend to 1. Hold fundamentalist religious views and interpret the Bible literally. 2. Hold authoritarian beliefs. Or 3. Be more concerned about crime, more trusting of police, more cynical about defense lawyers, and less tolerant of procedures that protect the accused. In addition, there are a number of attitudes that death-qualified jurors might hold, all of which can be determined through voir dire. 1. They may believe in the legitimacy of retribution and revenge, that executing a murderer would make them feel better. 2. They believe the death penalty deters criminals from committing atrocities. And 3rd, they may falsely believe that execution is cheaper than life in prison. One of the challenges of this procedure is, these juries are more likely to vote guilty before and after deliberation than non-death qualified juries. But, in 1986, the U.S. Supreme Court disagreed in Lockhart v. McCree. Here are some of the strategies associated with less biased juries. First, abolish or limit death qualifications. Second, abolish or limit peremptory challenges. Third, abolish or limit scientific jury selection. Fourth, rewrite the judge's instructions to be in plain English. And fifth, select diverse juries from representative pools. Together, these strategies can level the playing field and reduce wrongful convictions and inequality in the courtroom. In the next section, You'll learn more about the jury deliberation process,